Here we go. Not legal advice. Like, subscribe, share, subscribe, whatever else you can do on those stupid controls. Show your plants, animals, inanimate objects, former spouses, cousins, whatever. I have a bunch of stuff to talk about, probably mostly irrelevant, but I have a bunch of things to talk about. I'm going to do some of them, but I think I have too many things to talk about, so I'm going to split up this video, see how far it goes, and then I'll decide. But before, of course, I move any forward, this is not legal advice, of course. Please do not rely upon anything said here. Do your own research, analysis, review when you're sober. Be appreciated. So quickly, I wanted to say that there was a heated debate at the restaurant last night, so I decided not to take sides. And again, I don't know why I paused there, but I paused. The difference between an old bus station and a lobster with breast implants is that one's a crusty bus station and the other is a busty crustacean. And last but not least, and I want you to think about this one. Haven't we all thought about this? Just be honest. What if soy milk were just regular milk being introduced in Spanish? Did you ever think about that? Anyway, wanted to talk about a few things. First thing I'm going to talk about, I'm just going to bang them off. So tomorrow, if it goes as planned, Little JR, Mr. JR, as we like to call him, and I will be doing a live stream sometime around 11:20, 11:30 Eastern time on my YouTube channel, this channel. And we will be going over the Jarkesy case, which I've correctly spelled finally. That case relates to whether the SEC will have continuing, basically, judicial powers outside of the federal court system. And based upon that case, that might impact FINRA, because there's cases that are next may go in that route. So this is the oral argument. We're going to be watching it. I don't think we're going to watch on the live stream unless something happens that we're not expecting. But we'll talk about it for probably like 30 minutes or so after, and we'll give you our worthless views on what we saw. But it's an interesting case because it will impact the regulatory area that all of us are so interested in and think is so improperly mismanaged. So again, that's Jarkesy. That's tomorrow. Next in line, and I've heard and I appreciate everybody who does whatever they do in Congress and tries to get assistance, and I appreciate all the meetings. Wonderful activity, and this is primarily directed at the MMTLP crowd. Wonderful activity on your part. So that's my first statement. My second statement is, a year into this, gentlemen and ladies, and this is not the people from MMTLP, this is the people in Washington, D.C., please inform me why you are refraining from using your subpoena power. Now, I know it's a very precious power and a infrequently used device, but it is perfect to be used when the agency you should be regulating and supervising does not comply with your gentle requests. So either, and this is my demand, my personal demand, either tell me that you will not be using your subpoena power, or tell me that you will. One or the other. If you're not, then there's no reason for me to bother you any further. I would expect polite requests of the regulators who have not complied to this point in time would also be declined politely. So absent some use of your real power and subpoena, I don't think you're going to be able to obtain information from whatever regulators you want to get information from and whoever is requesting it. So I know Congress does have subpoena power, and just for me, I'm only asking for me. Why don't you think about using it, especially if the people that you're trying to regulate are thumbing their nose at you? I really am surprised at what you will take. So that's that. Going back to Jarkesy really quickly, I should have mentioned this. 3 issues quickly. Violation of the 7th Amendment, right to a jury trial, because there was a claim for damages. 2, a violation of non-delegation provision, and 3, a violation of Article 2 of the Appointments Clause. This should have been a judicial appointment or ability to remove from the executive branch, not just from the SEC. Those are the 3 issues that are going to be heard in Jarkesy. So we've done Jarkesy. We talked about subpoena power. I was going to talk briefly about what's going on in South Korea and Thailand. Ham and William, I think, are going to South Korea. They're going to be meeting with people. South Korea has recently banned short selling. I believe Thailand is doing something comparable. So they're open to addressing this. Perhaps they will list American companies, small American companies, that regularly are shorted in one of these exchanges. Don't know, but I think that's the intention, or the intention to explore those areas. And it may be the case that once negotiations are ongoing, that shorts who are holding those positions might grow a little bit anxious to close those positions because they don't know if that will result in a deal that might put them in a worse position. So the fact that these discussions involving Ham and William and whoever else in South Korea, Thailand, Singapore, wherever else they're going, it'll be interesting to see what the impact would be if these negotiations spur on future agreements or the potentiality of future agreements. I will be really interested in the impact and effect. So that's that. Alpine. So I've heard a lot of people, and JR and I did a video live stream about 3 weeks ago, where I was speculating about the conclusion of the Alpine case, and I referenced Rule 11, etc. And I also indicated that because it was a spoofing case, that requires the proof of certain elements, and you may not know if you're going to be able to prove those elements when you start a case, but it might change. And spoofing's different than counterfeiting or the shorting issue that we all talk about. So we haven't heard anything further from either the company or from the law firm, and there's been no regulatory filings. And I believe if there had been some, and I think I mentioned this at the time, but now time has passed. So now I can reflect upon what's not occurred and then draw some conclusions, although I don't have firsthand knowledge of it, to be honest. So I'm just using this based upon how I read the situation, my experience, etc. But if there was a material settlement of that case, it would have to been reported in a regulatory filing. Now, perhaps that time hasn't run, but I think it would have, and they certainly could have done it at earlier as opposed to later. So since we haven't heard anything, I'm speculating that whatever that resolution was did not involve a monetary settlement. Because if it was a significant monetary settlement or a settlement providing other benefits that were of a substantial nature, it probably would have or should have been reported. So the fact that we haven't heard anything from anyone else suggests that it was probably a mutual dismissal. So both parties agreed to move on their way. And again, this part I'm speculating, but it may be the case that it was of the action, spoofing, requires certain proof on certain elements, and maybe it's difficult to prove, and maybe that's what they discovered. And again, just to explain that, you could have certain activity that goes on. So somebody takes your shoe. Can you prove that as a theft? There might be 5 elements that you need to prove, and maybe you can't prove. Like, for example, maybe you have to show that the person intended specifically to steal your shoe. But maybe they just weren't very careful. So maybe you could plead negligence. That would be a different claim, even though it covers the same kind of activity, and it would require a proof of different elements. So it may be a case with spoofing that after consideration, it just wasn't that claim per se just wasn't going to work within that situation, but it has nothing to do with counterfeiting or I don't want to use the term naked shorting, but all the excess shares that exist wherever they are, that's independent and a different claim than what the spoofing claim is. But I've heard questions about it, so I just wanted to address it again. So that's my take on it. Some type of mutual dismissal. I don't think there was any significant compensation going towards plaintiff. I think it was just a decision that there were other avenues to pursue, and the parties moved on. And again, it doesn't have any impact on the counterfeiting situation, whatever. But I've heard that issue brought up a few times. So that's my take on it. Until I hear otherwise from either the company or the law firm, that's kind of my speculation on it. And cases are often dismissed, so it's not unusual. And again, you could have one claim, you could have more than one claim or more than one suit that fits certain facts. So just kind of wanted to address that. So that is now GTII. And last but not least, and I'll do arbitration next one, but last but not least was the story I heard about the Star Spangled Banner that I never heard before. And it involves a lawyer. So well, I don't know if everybody knows who wrote the Star Spangled Banner. It was Francis Scott Key. He was a lawyer, and he wrote it in the War of 1812. I just learned this. So if you don't know it, then don't feel bad. It took me a long time to hear the story. And the War of 1812 was going on between the United States and the British, and there was a prisoner. Both sides had prisoners, and they wanted to do a prisoner exchange. So they designated Sir Francis Scott Key, who happened to be a lawyer, to negotiate on behalf of the Americans. They boarded a ship, a British ship, that was in the harbor. In the hold of the ship, there were a bunch of prisoners. And the idea was to negotiate a swap of British for American prisoners. During the negotiations, the discussion went on, and the British commanders indicated that this swap was kind of irrelevant because the British were coming anyway. And were going to have a bunch of ships, and they were going to attack the fort. I think it was Fort McHenry, that sat on the shoreline. And in the center of that, and there were women and children and soldiers that also in that fort. In the center of the fort, there was a big flagpole and a flag, an American flag. So Sir Francis Scott Key is on the boat. He looks out towards the water. He sees all these British ships coming to attack. Late at night, that same night, they come, and the men who are still prisoners down below are asking what's going on. And Francis Scott Key is telling them what's going on, describing the battle that's going on and the attack on Fort McHenry. So the British unload all their arms and ammunition, and they continually bombard the fort, and they decimate the fort, and they hit the flag and the flagpole multiple times, but this shroud of smoke comes up. And in the morning, as it turned out, despite all this battle, the flag was still standing up, although battered and beaten and tethered. The flagpole, slightly askew, was standing up. And it turned out what happened was every time the flag got knocked down, the men of the area and maybe other people went and held the flagpole up, literally. And when they died, other people would replace them. And in the morning, the flagpole was still standing. So when you hear the national anthem and you listen to the words of that song, that will make a lot more sense, because that's really the story of Francis Scott Key, the men who were the prisoners underground, and the people at the fort who knew the symbol of the flag and gave their lives to keep the flag flying. And we prevailed in the War of 1812, or I wouldn't be on YouTube right now. Anyway, hope you are all well. Hope that was an interesting story. I found it an interesting story when I heard it. Be well. I will have another video tomorrow. And again, JR and I will be doing a video or a live stream on the Jarkesy case in the Supreme Court tomorrow. Look forward to it. Be well. Take care. Have a great night. Bye-bye.